Hey, beautiful people, welcome back. Withdrawal of plea. Two specific things regarding plea withdrawals. If one has pled guilty to any given situation, they can always withdraw it. In the past, we went over specific parliamentary procedures that governs how and why and the conditions behind withdrawal of pleas. And in furtherance of that, two more conditions. It must be done voluntarily, which was went over. And the conditions behind what determines whether it's voluntary or not is what we're going to go over now. And the time period to which one can withdraw a plea or not. In summary, a plea can be withdrawn anytime before sentencing. Sentencing is usually done after trial. But that withdrawal is contingent upon the voluntary act. If you did it voluntarily, meaning you had pled guilty in the past, without any duress or any underlying factors, then it will be much harder for you to withdraw it. But if that plea of being guilty was involuntary, one way or another, either through lack of information or through coercion, which is intertwined with principles of a contract, the act of pleading, whether through paper, any form of motions you put in our evidence, those are pleadings, or whether you're pleading guilty or not, those are all contracts. So that pleading, in this case, guilty or not guilty or no contest, must be done voluntarily. A lack of information can be part of what constitutes involuntary plea. So those two conditions of voluntary plea and the time period in which pleas can be enforced, plea withdrawals can be enforced, is within the appellate court case decision, year 1997. Juan Rivera, appellant, versus the state of Texas, appellee. So this guy was once the defendant, and now he's appealing it against the power of the state of Texas that was brought against him. Court of Appeals of Texas, San Antonio, July 16, 1997. The appellant was indicted by Bexar County grand jury for the offense of murder. Rivera entered a plea of nolo contendere to a reduced charge of voluntary manslaughter and was found guilty of that offense. Punishment was assessed pursuant to a plea bargain at 18 years of imprisonment in Texas Department of Criminal Justice at $1,000 fine. Meaning he pled no contest, which in some jurisdiction is considered guilty if there's no presumption of innocence. Meaning you're not saying you're guilty or not, and you can enter that as a form of plea. But where there's a presumption of guilt, that is deemed also synonymous with guilt. And by virtue of that, they just merely reduced it, and he was nonetheless sentenced. Background. At the plea hearing, Rivera was admonished about his no contest plea, meaning they told him about what's going on and the repercussions of it and whatnot. Whatever the specificity of it is, I don't know. Rivera indicated that he had read and understood the jury waiver and the warning contained therein, meaning he waived his rights, and stated that he had decided to give up his right to jury trial, meaning, look, let's just get this over with. After Rivera tendered his plea of nolo contendere, the trial judge determined there was sufficient evidence to convict Rivera, and despite him pleading no contest, he was presumed guilty nonetheless. Rivera accepted the plea and ordered a pre-sentence investigation prior to sentencing. And you know what? Let's look further into it. Or let's use this as an opportunity for him to do supplemental pleadings if he knows he can do it. Shortly thereafter, Rivera filed a motion to withdraw a plea. Then he said, whoa, hold on. I see something is going on here. Something isn't right. This is what they wanted me to pick up. Otherwise, why didn't they just go straight to sentencing? Shortly thereafter, Rivera filed a motion to withdraw a plea. Before this motion was ruled upon, Rivera obtained new counsel. Rivera's new attorney filed a first amended motion to withdraw plea. A hearing. Now, by the way, you was wondering, wait, hold on. If this guy had filed a motion, why is the attorney filing the first amended one? Well, that's because now he has to interject himself into it. And the only way he can interject himself as a party in interest is by amending it. Even if all the verbiage of the initial motion to withdraw was the same, and the only thing that changed was him as the counsel, it is still considered amendment because there's a new party involved. In this case, a consensual one, because this guy withdrawing his plea hired the attorney. A hearing was held on this motion, therefore due process, to see, okay, what is it now? At which Rivera and his prior counsel, the old counsel which he had fired, Cornelius Cox, testified. Rivera told the court that his former attorneys informed him he had an automatic right to withdraw his plea prior to sentencing. He said he thought he could withdraw his plea and have a jury trial if the court found him guilty. He also stated that he did not read the plea papers because he trusted his attorney. A lot of people suffer from this syndrome. Cox then testified on behalf of the state. Of course. Cox stated that he generally goes over the paper. Generally. No specificity, no explanation, no ifs, then, no complete breakdown. Cox stated he generally goes over the plea papers and documents with his clients and denied telling his client that they could withdraw a plea at any time, which is one of the factors here. Can you withdraw your plea at any time? That's what we're going to figure out. Cox did admit, though, that there was a possibility that Rivera was led to believe he had an absolute right to withdraw his plea prior to sentencing. Cox also stated that he understood the law to provide for the withdrawal of a no contest plea prior to sentencing. After hearing the testimony presented, the court denied the motion. Meaning the court now saying, look, we're not going to withdraw your plea. In his first point of error, Rivera contends that trial court erred in refusing to allow him to withdraw his nolo contendere. Meaning, remember, this is the appellate court now, and this is what went on previously that he is now appealing. It is the court that he was sentenced at saying you can't withdraw your plea and we don't care. And that was the background that the appellate court is putting into consideration. A defendant may withdraw his guilty plea as a matter of right anytime until judgment has been pronounced or the case has been taken under advisement. Whether to allow withdrawal of a plea pursuant to a motion filed after the judge has taken the case under advisement, though, is within the sound discretion of the trial court. Meaning their discretion can only be enforced after they've been notified that he intends to withdraw the plea. Once the trial judge has admonished the defendant, meaning just inform him of his rights, which they did, and he waived it, right to jury, right here. Of course, that must have involved the right to withdraw and all that. Because whenever you plead, you effectively waive trial. Whenever you plead, the whole purpose of pleading is to avoid all the technicalities of trial and just get straight to the point. You jump. That's the purpose of doing a plea of guilty, non-guilty, no contest. Because the whole purpose of trial is to test the sufficiency. But when you plead guilty, non-guilty, or no contest, you're saying, oh, well, no need to do trial now. This is what it is. Whether to allow withdrawal of a plea pursuant to a motion filed after the judge has taken the case under advisement, though, is within the sound discretion of the trial court. Once the trial judge has admonished, meaning informed them, the defendant received the plea and received evidence. The passage of the case for pre-sentence investigation constitutes, and the only thing left after that, taking the case under advisement. And I'm just going to now do an overview of everything that's going on and put that in my notes. As Rivera did not file his motion until after the trial judge had taken the case under advisement, we reviewed the court's decision in this case under an abuse of discretion standard. Meaning we're not saying he's right, we're not saying he's wrong as to whether he could have withdrawn his plea during a certain period or not. But what we're going to do, though, is we're nonetheless going to entertain it with the lens of whether the judge did the right thing or not. To establish an abuse of discretion, the appellant must show that the trial court's ruling lies outside the zone of reasonable disagreement. Quote, Rivera claims the trial court abused its discretion in denying his motion to withdraw a plea because his attorney at the time he entered his plea misinformed him of his rights regarding withdrawal of the plea, which rendered his plea involuntary. So now he relied on his attorney, a professional, right, in legal matters, which swayed his mind outside of his independent decision, aka involuntary, to go ahead and enter the plea. It is well established that a guilty plea must be freely and voluntarily entered. If an attorney conveys erroneous information to his client, a plea of guilty based upon that misinformation is involuntary. We conclude that the misinformation conveyed to Rivera by attorney Cox in this case rendered his plea based on the misinformation involuntary. We note that a defendant claimed that he was misinformed by counsel. Standing alone is not enough for us to hold his plea was involuntary. However, Rivera's testimony at the hearing on his motion to withdraw his plea was uncontroverted and was indirectly corroborated by the testimony of his former attorney, and he was not rebutted. And we actually don't necessarily agree with what he's saying, but the attorney he's pointing finger at said nothing, and in fact somehow kind of agreed with him. Rivera maintained that Cox told him he had a right to withdraw his plea and have a jury trial anytime prior to sentencing. Cox never denied telling Rivera this. In fact, Cox admitted it was possible that Rivera believed he had an absolute right to withdraw his plea prior to sentencing. Cox also stated his understanding of the law was that a defendant had a right to withdraw his guilty plea any time prior to sentencing. Although this is not entirely incorrect, meaning you can withdraw your plea prior to sentencing. Although this is not entirely incorrect, it is not a complete statement of the law. Okay, so it could be true that you could withdraw your plea before sentence, but there are conditions to that. As discussed above, once the trial court has taken the case under advisement, then they're intending to now close everything out. such as by ordering a pre-sentence investigation like the one in this case, the defendant does not have an absolute right to withdraw his plea. So the defendant can withdraw his plea before sentence under the condition that any type of court order has not been made regarding what they're going to do next. There it is right there. The defendant does not have an absolute right to withdraw his plea. It is not a complete statement of the law, meaning the ability to withdraw a plea prior to sentencing. As discussed above, once the trial court has taken the case under advisement, such as by ordering a pre-sentence investigation like the one in this case, the defendant does not have an absolute right to withdraw his plea. So a plea can be withdrawn before sentencing so long as an order does not precede things. Once that order is done to precede it, that's it. That right to withdraw your plea before sentencing, gone. Based on Cox's understanding of the law, the attorney, previous one, it is not difficult to see how Rivera could have been misled into believing that he could withdraw his plea and have a jury trial. Again, pleas waive trial, which is to test the sufficiency of the claim. Misled into believing that he could withdraw his plea and have a jury trial even after the trial court ordered a pre-sentence investigation. Rivera testified that his belief based on the misinformation from Cox was a factor in his decision to plead no contest. Because Rivera's plea was based on misinformation from his attorney, it was not voluntary, and the trial court abused its discretion in denying the motion to withdraw the plea. Rivera's first point of error is sustained. As Rivera's first point of error is dispositive of this appeal, we do not reach his second point of error, alleging ineffective assistance of counsel, which we've run over this. The only thing that they are obligated to you is just to inform you of your rights. Outside of that, they don't owe you anything else, and you cannot claim that the assistance was ineffective. And this is the way out for them. The judgment of the trial is reversed. In this case, he's remanded for further proceeding. Bottom line, you can withdraw a plea before sentence so long as an order does not steer the motion of things to that sentence in itself. And two, the plea that you're attempting to withdraw must be done voluntary, along with all the other factors mentioned in the earlier videos regarding plea withdrawals. There it is. Take care. Best of luck. A quick shout out to my patrons, and to those who have not yet joined my Patreon, I'm inviting you, come on over. On the Patreon page, we speak about things that are not shown here on YouTube. We speak about the private side of the court, outside of just the finance. We speak about how to prove actual fraud and lift the corporate veil. In addition to some study tools, we speak about how to actually invoke private right of action there in the Bill of Rights. We speak about financial things with letters of credit, property rights, preservation of property rights. We speak about how to put your vehicle in a trust and how to not qualify for tax, how to properly fill out the GSA, public laws of the state and common law, how to establish probable cause. There are different types of damages. There's damage and there's damages. Those are two different things. The type of relief that you seek to be granted is a huge part of the type of damages. We go over that. We speak about the details of the bills of right, which is what you would really be invoking whenever you bring in any claim, whether on a financial level, private level, whatever it is. We speak about how to remain private when it comes to the Oscar algorithm and how to establish certain types of profile. We speak about how to go after bonds. We speak of how to get federal judges and other federal employees oath of office and bond. We speak about the different types of discharge and the specific ones, and we go over the details and more and more to come. Take care and best of luck.